Good afternoon, and unless Judge Clement has misled me, we only have one case left. So, Ms. Clerk, would you call the case, please?
John A. Gentry versus Speaker of the House.
Good afternoon, Your Honors. My name is John Gentry, representing myself and the people of the state of Tennessee sui juris, and I respectfully reserve 3 minutes time for rebuttal.
Yes, sir, 3 minutes.
So there's two matters before the court. Did the trial court dismiss the case based on application of res judicata in error? And the second question, whether or not application of res judicata, whether it's in error or not, is a violation or is a pretense and in violation of Article 11, Section 16 of the Tennessee Constitution. This case is about restoring the right of citizens to orally address the legislative houses and application of res judicata, whether it's error or whether it's in error or not, is a prohibited pretense. And in Mayhew v. Wilder, citing an 1881 case, Lynn v. Polk, any act of the legislature in violation of the Constitution, the courts can and must be stopped by the Judicial Department of the state. And if the courts cannot interfere with the Constitution, if violated, is dead letter. And the Constitution of this state is not dead letter law. The courts have the power over other branches to enforce the Constitution, and they must exercise that power. From Article 1 of the Tennessee Constitution, Section 1, power is inherent in the people, and we have an inalienable, indefeasible right to alter, reform, or abolish government. And in Section 31, the people have the right to exercise sovereignty. And in Section 23, we have a right to instruct our representatives. To say power is inherent in the people, and we have the right to exercise sovereignty and the right to instruct our representatives, but that we have not a right to orally address our legislative houses is absolutely absurd.
Mr. Gentry, why is the right to address the legislatures on the floor of the state house? So you're looking at the language address, right? Why is that addressing a right to stand on the state house floor and make that argument or request or petition to representatives?
Sure. In Article 1, Section 31 of the Tennessee Constitution, it says, these are the boundaries of the state, and over this land, the people have the right to exercise sovereignty within the constraints of the Constitution of the United States, and very importantly, recognizing the Constitution of the state of North Carolina, which Tennessee was part of. In the North Carolina Constitution, Article 1, Section 12, the people have the right to apply to the General Assembly for redress of grievances. And in Section 31, where it says recognizing the Constitution of North Carolina, Black's Law Dictionary definition, 5th edition, to recognize is to try, to examine in order to determine the truth of the matter. So when the North Carolina Constitution says we have a right to apply to those invested with the powers of government, they intentionally made that language more broad. Any of those invested with the powers of government, and we see from the North Carolina Constitution specifically to the General Assembly. So absolutely, Your Honor, we have a right to orally address the legislative houses. That fact evidenced in Article 1, Section 1, 31, and 23. When we look at what is a pretense, Black's Law Dictionary definition, 10th edition, pretense defined, a way of behaving that is calculated to make people believe something untrue. And it is always true that rights are not to be violated. And any action and any act oppressing a right is a prohibited pretense. In the defendant's brief, they said, she cites my prior case opinion and says the right to orally address the House is simply not conferred by the Constitution. Article 1, Section 23, citizens have a right to apply to those invested with the powers of government by address. It is absolutely in the Constitution. And history screams at us that we have this right to address our legislative houses. In 1669, the House of Commons resolved that every commoner in England has the inherent right to prepare and present petitions to it in case of grievance.
Mr. Gentry, there's some similar language in other state constitutions, and as you've already noted with North Carolina, state constitutions are known to borrow language from each other, moves from one state to another. Have you found any state court that has interpreted the language address and remonstrance as providing a right to actually speak on the floor of the state legislature? Is there any judicial decision by any state court interpreting similar language in that way?
The last time that this right was exercised before me was 1850. And this right was not oppressed, evidenced in the 1831 House Journal. Members presented petitions, and I'm going to get into this in a little bit talking about rules, but it's right in the House Journal from 1831. Mr. McGaughy presented a petition on behalf of Baptist McCombs, resolved that the petition is referred to the Propositions and Grievances Committee. And then another representative from the Propositions and Grievances Committee made a statement or a recommendation back to the body, and then the full body used to vote based on the recommendation whether to grant or deny the petitions or grievances that were presented to them.
Mr. Chair, let's assume, just assuming, not saying, but assuming for a moment that you're right, that there's a right to speak on the floor of the state legislature, state house. The Constitution also has separation of powers provisions. This court can't exercise the authority of the legislature.
Well,
it seems problematic for this court to order, or for the trial court to order.
I would disagree, Your Honor, respectfully. Since Marbury v. Madison, it has been the sole obligation of the judiciary to interpret the law and determine the constitutionality of actions taken by the other two branches of government. And in Tennessee Small School, 1983 Tennessee Supreme Court case, citing a New York case, it is nevertheless the responsibility of the courts to adjudicate contentions that actions taken by the legislature and executive that fail to conform to the mandates of the Constitution, which constrain the activities of all three branches. Absolutely. The purpose of the separation of powers is to provide check and balance. It is not to say that you can't interfere. The separation of powers is actually to provide that check that the other branches do interfere when the other branches are acting unconstitutionally. And to say that they're not, again, that makes the Constitution dead letter. And it is not, Your Honor. I need to get into arguments on dismissal of this case on res judicata. The court is well aware of the four factors of when application of res judicata is complete. The prior judgment was not rendered by a court of competent jurisdiction. In the previous case, I asked the entire appellate court to recuse. Judge Bennett, sitting in front of me hearing this case today, he signed an order that said, "We conclude that the judges of this case have an interest." And I quote, "Given the allegation in petitioner's remonstrance, there is no qualified pool from which either the Chief Justice or Governor could appoint special judges to hear this case. And Black's Law Dictionary definition of competent is a basic or minimal ability, adequate qualification." And that recusal denial said that there was not a qualified jurist in the entire state of Tennessee, which includes the chancellor, who I also motioned to disqualify, who also asserted the rule of necessity mandating hearing of that case.
Of course, the Tennessee Supreme Court approved the use of the rule of necessity in that case, though, right?
I don't dispute that, but the fact is that since there was no one qualified, it was not a court of competent jurisdiction, and pursuant to Article 6, Section 11, they lack subject matter jurisdiction in the case. Now, the other important part here is cause of action. In order for res judicata to apply, it has to be the same cause of action. And the definition of a cause of action is a group of operative facts giving rise to one or more bases for suing. The defendant in this case is confusing, or counsel for the defendant is confusing the remedy sought with the cause of action. The remedy I'm seeking is very similar in both cases, but the causes of action could not be more different. In the previous case, I filed a written remonstrance. In this case, I filed an application to be presented by oral address. In the written remonstrance, I sought reform of the judiciary.
Can I ask you about that point? You have in your amended complaint from 2019, language seeking to uphold and honor petitioner's constitutional right to petition by address orally.
But there's a new fact, and when we look at Regents v. Court, facts occurring after adjudication give rise to a new cause of action not barred by res judicata, Tennessee Court of Appeals 2009, and in Gerber v. Holcomb, citing a Texas case, res judicata is conclusive not only of matters actually raised and litigated, but also conclusive on every other matter that could have been litigated. I did not make application by address the first time because I was deceived by a false version of the Constitution that strips us of the right to make oral presentation to the bodies. And because I was deceived, I filed a written remonstrance. And after that, I learned that we have the right to orally address them because the Deputy Attorney General corrected me on what the actual language of the Constitution is. So these are completely different causes of action. The first one was written, seeking reform of the judiciary. The second one is made application by oral address, and I'm only asking the houses to welcome, hear, and decide petitions and reinstate the Propositions and Grievances Committee. So when we look at, there wasn't a court of competent jurisdiction of that, there is no doubt. When we look at this cause of action, they are not the same causes of action. It wasn't tried on the merits. The prior case was dismissed sua sponte. And there wasn't even an operating motion to dismiss before the court when they dismissed the prior case. And it's not the same party. Before I sued Speaker-elect, he was added to the amended petition that was dismissed without hearing. And in this case, I'm suing the Speaker of the House. They're two different people with two different powers. Thank you, Your Honor.
Thank you. General?
Good afternoon, Your Honors. Janet Kleinfelter with the Attorney General's Office. I am here on behalf of the Speaker of the Tennessee House of Representatives. This was a case seeking a petition for writ of mandamus to require the Speaker to essentially schedule a time and allow the petitioner the opportunity to come onto the floor of the House of Representatives and to orally address the Speaker and the other members of the House with respect to his application for remonstrance pursuant to Article 1, Section 23 of the Tennessee Constitution. The trial court, in the exercise of its discretion, dismissed the petition, finding that it was barred under the doctrine of res judicata because petitioner had sought the exact same relief in a prior case that had been brought against the former Speaker of the House of Representatives and then Speaker-elect, the current Speaker of the House of Representatives. That decision was upheld by this court, and the Tennessee Supreme Court denied the Rule 11 application for permissive appeal. The court's very familiar with the 4 factors for finding that res judicata is applicable. We've addressed those factors in our brief, and I'm just going to very briefly respond to the petitioner's arguments. With respect to the argument of competent jurisdiction, jurisdiction goes to the court's authority to hear a particular type of case. And there is no dispute but that Tennessee Code Annotated Section 16-11-102A, as well as Section Tennessee Code Annotated 29-25101 vest authority in a chancery court to hear and issue writs of mandamus. So there's no dispute under the statutes that the chancery court had the jurisdiction. Petitioner's argument is that the court was not qualified to hear this case because of an allegation of interest and did not obtain the consent that was required, or that, as petitioner contends, is required by Article 4, Section 11 of the Tennessee Constitution. As we pointed out, that goes to an individual judge's qualifications to hear a particular case, not the authority of a court to hear a particular type of case. And that is what res judicata requires, is that the court have the jurisdiction to hear or the authority to hear a particular type of case. Additionally, this court, in the prior decision, which I refer to as Gentry 1, held that the issue was waived by the failure of the petitioner to raise the issue timely in the prior proceeding. With respect to the judgment being final and on the merits, I've already recited the procedural history. The prior case was dismissed by the trial court. It was an involuntary dismissal, and as we've pointed out, Rule 41.02 of the Rules of Civil Procedure that says an involuntary dismissal that is for any reason other than lack of jurisdiction, improper venue, or lack of an indispensable party is considered to be an adjudication on the merits. The case was dismissed not for any of those reasons, and is therefore an adjudication on the merits. Additionally, as we pointed out, this court has held that a hearing on the merits is not required in order for the doctrine of res judicata to apply. That's the Ralph versus Scruggs farm supply case that we cited. With respect to the same parties, the Speaker of the House of Representatives was sued in his official capacity. It doesn't matter whether it is Glenn Cassida, who is the Speaker, or Cameron Sexton, who is the Speaker. It is the office that was sued, the Speaker of House of Representatives, and it was the Speaker that was sued as a defendant in both cases, so we have both parties. And the last factor is the same cause of action. And here, petitioner would ask this court to find a difference that we submit as a difference without a distinction.
General, in the first action, Mr. Gentry's seeking to have his petition read, right? He has a very extensive petition that he's generated. He wants it to be read on the floor of the State House. This time he wants to come in and speak. Aren't those two different requests? I mean, the first one, emphasis seems to be also on the language of remonstrance, where it was here, it seems to be about address. Doesn't that make it a different cause of action?
Respectfully, I would disagree, Your Honor, because what petitioner ultimately is seeking is to enforce the right under Article 1, Section 23. And both the trial court in the prior decision and this court found that there is no right there is no specific right to either hear or have heard by the General Assembly a petition for remonstrance or to orally address.
So what you're saying is there's really no difference between writing something and having someone read it to the legislature or getting up and saying it yourself.
Correct, Your Honor. And that's essentially what this court said in its prior decision. And finally, I would point out that this factual difference, which petitioner would ask the court to find to be sufficient to define two different causes of action, this court has said that requiring a subsequent cause of action to be identical to the original cause of action is too narrow of a reading of the doctrine of res judicata. And that is the only difference we have here.
General, is he asking, though, to read the petition, or is he asking to be able to make an argument before the State House?
Your Honor, it is not clear from the pleadings. I would suggest or submit, however, that that is exactly what the petitioner is requesting, is the opportunity to present the same remonstrance that he sought to present in the prior case. It is certainly with respect to the same subject matter that is what the petitioner seeks to present to the court. So we would submit, Your Honor, that the trial court properly exercised its discretion in dismissing the petition for writ of mandamus on the basis of res judicata. I want to briefly just address the alternative argument that the petitioner has raised. The argument that the court couldn't use res judicata, that is nothing more than a pretense. It's a prohibited pretense, and that he was otherwise entitled to mandamus. Two reasons why that is incorrect. First of all, this court has already held, and that decision was, at least the Supreme Court denied the Rule 11 application, specifically held that petitioner does not have a clearly established right to have his petition heard or considered by either house of the General Assembly. That was in the Gentry 1 decision at page 5. The court asked, has there been any other court or any judicial decision that has interpreted or has applied similar provisions, either in this Constitution or in other state constitutions, to find that a right exists to appear on the floor of the House to address the General Assembly? And this court actually addressed that issue in the prior decision. The court looked at the history of this decision, the history of this provision, and discussed cases in which similar provisions have been construed. None of those decisions have construed the right to petition government as conferring the right to appear to orally address the court. And that is because, as we pointed out, and as Your Honor has recognized, we have the separation of powers, and we have another provision in the Constitution.
I suppose if we were to accept this argument and take it to a logical extreme, that means, every representative is a citizen of the state. If they all have this same right to redress, that would mean every piece of legislation they presented would have to go to the floor of each house, and they would have to have the opportunity to present it if we accepted Mr. Gentry's argument.
Exactly, Your Honor, if you take it to that extreme. And that's why we have the provisions in Article 2, Section 12, which confer upon each house of the General Assembly the right to establish, to make, interpret, and enforce their own rules of proceedings. And that's exactly what the House of Representatives have done.
General, I have a question in terms of that argument, Article 2, Section 12. The Tennessee Supreme Court has been pretty clear, I think, that this court is not supposed to raise issues that haven't been addressed by the parties. Do you think the state's argument with regard to Article 2, Section 12 is broad enough for this court is it presenting a separation of powers argument? Is that, or am I overreading your Article 2, Section 12 contention? The proceedings language, is it broad enough to pull in separation of powers, or is that something that if this court was to consider the merits, would additional briefing be warranted or necessary?
No, Your Honor, because, again, remember, this was a petition for writ of mandamus. Mandamus is an extraordinary remedy and can only be granted if there is a clearly established right and a clearly established duty to perform something. And our point here with respect to Article 2, Section 12 is that the House of Representatives is constitutionally vested with the authority to make their own rules. They've done that. They've made their own rules. And the trial court acknowledged that under those rules, there was no authority given, or there was no ability to provide that anyone could address the Speaker except a member of the House. A member of the House of Representatives. And therefore, the petitioner has no right under the rules which can only be made and enforced under Article 2, Section 12 of the Tennessee Constitution. And because he doesn't have that right, then under the merits argument, there is no right to a issuance of a writ of mandamus, because again, you have to find that there's that clearly established right. So I don't think the court even has to get to the separation of powers argument. And this was squarely addressed by the trial court in the trial court's decision dismissing the petition for writ of mandamus. My tongue's not working today. For all these reasons, Your Honor, unless you have additional questions, we would respectfully request that the court affirm the trial court's dismissal of the petition for writ of mandamus.
Thank you.
Thank you.
Mr. Gentry, you reserve 3 minutes.
So let's talk about rules, Your Honor. This is the legislative rules of order. Rule 15, petitions shall be read at the table. Shall creates a duty. Petitions shall be received and read at the table. Rule 79, anything not governed in the permanent rules of order shall be governed by Mason's legislative rules of procedure, latest edition. This is the latest edition. Section 149, subparagraph 4. Petitions are presented by petitioners themselves. This is a constitutional right that we have. When we talk about separation of powers, what it says is you're not supposed to exercise legislative powers. They're not supposed to exercise judicial powers. It says nothing about one branch not interfering with the other. Article 6, Section 7, judges Article 6, Section 6, judges may be removed by concurrent vote of both houses. Article 5, judges can be impeached. So can the legislative branch interfere with the judicial branch, and the judicial branch can't interfere with unconstitutional legislative conduct? It's absurd. Of course, your courts have the power to interfere with government. And she says the Constitution is not clear. Constitution is not clear. That would make it void for vagueness. And the Constitution is not vague. It is clear we have a right to address those invested with the powers of government. Their rules say petitions are presented by the petitioners themselves. It's in their rules. They have a duty. It's a constitutional right that we have. And let's talk about how important this right is. In the book Constitutional History of Medieval England, petitions, common and frequent, without the threat of force, took the place of prolonged discontent and the presentation of grievances at the point of a sword. This right took the place of violence, and it is the oppression of this right that we see the Black Lives Matter riots. It is the oppression of this right that we see the breaching of our Capitol in Washington, D.C., because this right is oppressed. And if this right is not restored, we're going to see more violence, more insurrection. And this court has the power to enforce the Constitution. The legislature has a duty to present petitioners to the body to make their oral address. That right was asserted. It was received by Representative Johnny Garrett. It was filed with the clerk of the House. And once those actions take place, we have a right to orally address the body. Of course we do. History screams at you that we have this right, Your Honor. And I would look forward to the court enforcing the Constitution of this state and remanding this back to the Chancery Court so that we can get a mandamus for the Speaker of the House to perform his duty. So thank you, Your Honor.
Thank you, Mr. Gentry. Thank you, General Kleinfelter. There being no other cases to hear, would you please recess us?
All rise.